litigation.
Thank you. Thank you, Ms. Theodore. I just have a couple really quick questions. It's maybe along the same lines as Justice Alito's, but it does seem a little unfair to me that you're asking us to pick your opponents. I'd rather, in court, I'd rather have only one person arguing against me rather than two. But I think that's a little bit of a conflict there. I mean, what are you afraid of? I mean, I'm sure you could handle two of them as easily as one.
Well, I'll say again that we haven't picked our opponents. We sued the people who federal law Ex parte Young in Article 3 allowed us to sue. So we didn't make a decision there. But I think what Rule 24 is about is simplifying litigation, and it says we don't add another defendant, we don't add another plaintiff unless there's a really good reason. And here there isn't one.
You keep saying we. I mean, the point is that it's a court interest, and the question is whether the court should be letting the state have the two representatives that under state law they say they should have. And I mean, I don't mean this the way it might sound, but I don't know why we're terribly interested in what your views are on that in the first place, because you're the one who's going to benefit if we throw one of your opponents out.
Well, I think Rule 24 is there to protect plaintiffs and defendants. It's there to simplify litigation. It's there to reduce cost and burden, and that's an interest that protects the litigants, including us. I think, we have an interest, and I think the court probably should have an interest in sort of not announcing rules that make it easier for governments to just say we're going to make it harder for people to challenge the government. So I think we do, as plaintiffs, have an interest.
Thank you. Justice Breyer, anything?
Well, I'll go back to this once more.